Here's to Main Street, not Wall Street. Here's to being invested in each other. Here's to a return to what matters. Elevations Credit Union. It matters where you bank. Visit us online to see why.
Good. My name's Lou Italiano. I'm with Fidelity National Title. We're the sponsor of the Legalized Marijuana panel that we're going to introduce here in a second. I wanted to introduce a few folks that came with me today that make these classes possible. This is Linda Geese, Ginger Perrietti, Dale Todd, he's out on parole. He was cultivating, but we won't go there.
I got busted. One thing you'll learn about, and you won't be putting this on your contracts, you're not going to be doing crop prorations.
I'll note of that. Yeah.
So we get a little plug here just for a second. Fidelity National Title is the largest title insurance company in the United States. But locally, we started in Denver in 1946 as Security Title Guarantee. We have 26 offices statewide, over 200 employees. We pride ourselves as being title professionals, and we want to say thank you to all of those that have used Fidelity in the past and invite any of those that haven't used us to give us a chance in the future. These folks will take good care of you, and so that is my plug. I'm going to go ahead and introduce our moderator today, Steve Morgan. Steve is Chief Operating Officer and General Counsel for the Colorado Association of Realtors. He oversees the legal hotline and speaks frequently to local realtor associations and industry groups on a variety of real estate and legal topics. Steve brings more than 25 years of experience to the association with a background in business and real estate law. Please join me in welcoming Steve Morgan.
Thank you. Thank you. And thank you to Fidelity for being here this morning, sponsoring this presentation. We appreciate it. Before we get started, a couple things. Let me just give you a little background on format. Is that too loud? Good? Good. This is going to run until 10:25. What we're going to do is Peter and Scott will be presenting about 10 or 15 minutes of information material to you, and then we'll open it up into a Q&A. And then I think it's a 10-minute break at 10:35. We will start the second half of this, if you will, which is just going to be a legal panel with a Q&A session. And Peter will be leaving, and we'll have another attorney joining us. So we'll have plenty of times for the Q&A in the second hour as well. So that you know the format. Before we get started, he had mentioned to you that I'm general counsel at CAR. And one of the things that we have at CAR, one of our services that we have for members is the CAR Legal Hotline. Has anyone here used the CAR Legal Hotline? A bunch of you. Anyone here who doesn't know what the CAR Legal Hotline is or anything about it? A few of you. So I'll mention it briefly. It's a free service, and you can register at our website, and we confirm that you're a member. The only restriction is that each office is limited to having 2 people registered at any one time. So you can have a couple people in your office register that have an ID or have access to it, and then they can call and ask any question. Any broker can get on the line and answer any question. The hours are from 10 to 12 and 2 to 4 every day. And in January, we're going to expand that. It's going to expand to 6 hours a day. So I just want to make you aware of that service that we have. Scott Peterson, who I'll introduce here in a second, works on the hotline as well as myself, so we've probably spoken with you at some point or another. So let's get started with our panel this morning. No one had any brownies for breakfast before this session, right? All right. All right. We're all sober this morning. All right, Peter. Let me introduce you first. Peter Wall is with CRL Associates in Denver, where he specializes in monitoring local governments. He also weighs in on special districts and a variety of public policy issues, including land use, procurement, and issues, one of which he did a lot of work on was all the legalization of marijuana in the past. Prior to joining CRL, Peter staffed a wide variety of political campaigns from congressional to local races. He's here this morning to provide us some background and insight on the legislation regarding marijuana in Colorado. We also have with us this morning Scott Peterson. Scott is a commercial broker and is an active member of the Denver Metro Commercial Association of Realtors as well. He'll be providing some perspective from the commercial sense. He also sits on our CAR Legislative Policy Committee, so he again has been involved with these issues for a number of years. He's a licensed attorney and maintains an active law practice representing individuals and businesses in real estate, business, and estate planning transaction, as well as I mentioned earlier, service in the legal hotline with us. Scott will review both practical and legal implications that the legalization of recreational marijuana is having on our industry. So with that, Peter, I'd like to turn it over to you, and we'll let you start with your presentation.
Wonderful. Can everyone hear me? Perfect. Well, it's too bad I had two funny guys up here this morning because all my marijuana jokes are gone. You might hear a bad one, but bear with me. Sympathetic laughs are always welcome. But thank you very much for being here today. I know most of you probably thought the sponsors were going to be offering up goodies. Not the case. We're going to be hopefully giving you some good info on marijuana. And backing up, I'm going to be trying to give you guys just kind of a general run-through of what was Amendment 64, how did we get here, where are we going in the future, what did the legislation look like, and really what kind of powers it gave local governments in terms of acting in ordinances, regulations, etc. So, let's see if I can do my clicker here. Starting out, Colorado and Denver have truly been on the forefront of this industry. It started out in 2000, well over a decade ago, when Colorado voters legalized the use of medical marijuana, both for users, and they also legalized dispensaries. Now after that, you probably didn't see a lot of these medical marijuana dispensaries pop up. Reason being is there's a lot of gray area, and continues to be a lot of gray area in terms of what the federal government thinks about marijuana. So we saw the Bush administration, which was very clear that it might be a priority and they would be potentially cracking down on patients and dispensaries. And then with President Obama being elected, first year into his first term, we saw his office make it very clear that cracking down on medical marijuana, both users and dispensaries, would not be a high priority for his administration. Thus, in 2009, you saw a huge boom of medical marijuana dispensaries, a lot in Denver and in and around the metro area, virtually helped save the commercial real estate market. You saw a lot of influx of folks in dispensaries and spaces that got bought up by dispensaries, so it really brought down vacancy rates significantly. Then in November 2012, folks may remember a couple years ago, unless you've been really taking advantage of Amendment 64. Thanks. 2012, Colorado legalized recreational marijuana. Pretty significant difference in the vote, 55% to 45%. I luckily had the wonderful opportunity to work on the No campaign and somehow ended up with a job after it. So now I want to talk a little bit about, just kind of refresh your memory about what Amendment 64 did. On the most basic level, it allowed persons 21 years or older to possess and use up to 1 ounce of marijuana. I wouldn't really recommend using the whole ounce, just possessing it. Allowed for the licensing of retail stores, growing facilities, manufacturing facilities, testing facilities. It required our General Assembly to enact an excise tax, as well as some legislation around the retail sales, the growing, the manufacturing, the testing facilities. And probably most importantly, it really gave municipalities local control. And when I say that, it allowed them to choose to opt in to retail and recreational marijuana, or it allowed them to opt out. It allowed them to establish moratoriums. It also gave them the choice of, they could simply have retail stores, they could simply have growing facilities, they could do retail, growing, manufacturing, testing. It really was kind of a hodgepodge of what they wanted to do that would fit within their communities. So it was a nice little carrot that gave these folks local control at the end of the day. I'm going to show you a map here in a couple of minutes, but what we've seen generally is most counties in Colorado have really chosen to opt out or establish moratoriums. I think it's a bit of a waiting game to see, folks like Denver, Pueblo, Eagle, Pitkin County, Boulder County, to see how they handle the local licensing and regulations, to see what works, to see what doesn't, and then from there potentially opt in. So I think we'll see more communities opt in at the end of the day, but for now, a majority of Colorado communities are opting out. Larger counties, including Adams County, Jefferson County, currently have moratoriums. Jefferson County put together a task force that recommended to their commissioners to never allow the sales of retail marijuana. Hasn't been voted on yet, but it's things like that where those counties and local jurisdictions have the ability to kind of weigh their options and then eventually make a decision whether to allow retail sales or just, again, some of the manufacturing, the growing, the processing facilities. That'll give you kind of a better idea. All those counties in green are the ones that have decided not to opt into retail marijuana right now, but again, they do have the right to go back if they chose to do so eventually. Blue ones are those that have chosen to opt in, and then the others are, again, kind of that hodgepodge of, some are doing retail sales, some are doing growing manufacturing. So where are we today? Obviously, we have the industry now. Retail stores are open. The Department of Revenue started issuing licenses January 1, 2014. Local municipalities do have a control. So if they're in a county, they actually have the ability to make their own rules and regs and decide to opt in and out. So, for instance, Denver, although it's its own county, has went through a pretty extensive licensing and regulation process, and at the end of the day, they made a smart decision and decided that they were only going to let their current medical marijuana facilities operate until 2016 to really use those folks that have the institutional knowledge, let them create the recreational stores and actually combine the recreational and the medical stores. And really kind of work out the kinks before new operators open up. So January 1, 2016, new stores can open in Denver. I think with that said, I don't think you'll see a huge influx of new stores. I think the ones that are already doing it have a good corner on the market. Frankly, there's not that many spaces in Denver and a lot of surrounding municipalities where you can find the appropriate zoning to make a store work, whether it's a retail store or a growing or manufacturing facility. So I don't think we're going to see the huge boom in stores. I think the ones that are already there are going to continue to operate and do it successfully. The other interesting thing is Denver, for new stores, created something called a needs and desires hearing, which is exactly how alcohol was. I mean, that was one of the carrots in Amendment 64, was really regulate marijuana like alcohol. So at the end of the day, a new store has to sit there and go through a needs and desires process and prove that there is, in fact, a need and desire in the community for a new retail marijuana store. And now I just want to go over, a number of the kind of policy issues, future impacts that we're seeing. Again, federal government positioning is going to be huge. I think, while it is trending towards a national issue, I think there will be a decision at the end of the day nationally. You just never know with a change in administration and a change in Congress how they may feel and if they want to really kind of sit there and crack down on the industry. Tax implications is a big one. Out of Amendment 64, voters were really promised a significant amount of tax revenue. That hasn't exactly panned out, I think, because a lot of those counties that we saw up there have chosen to opt out and aren't contributing to those sales. Revenues are about half of what they projected. They projected about $34 million for the first year, and revenues will be about half of that. So not exactly what voters expected. It's a lesson learned for other states that do it. Don't promise more than you can actually get there. Keep the numbers low and manage expectations. Banking won't go into, but it's another huge issue. This is a cash industry, and frankly, that's one of the reasons that you see some of the violence and criminal activity around the industry is they're not going for the marijuana, they're going for the cash that's in the stores. Property rights, realtors, biggest issue that we looked at, it's the balance of it's now someone's constitutional right in our state constitution to smoke and possess and grow in their own home. And how do you manage that with the impacts that it has on a neighbor? If you live in an HOA, how do you manage it to the point where you allow someone their constitutional right without allowing it to become a nuisance for everyone around you? Issues of constitutionality and local regulation. Denver actually limited the number of plants that are allowed to be within a home. Home grows has been a major issue. they've caught 90-year-old ladies with 85 plants in their home growing. I kid you not. So Denver actually limited that. In Amendment 64, each person is actually allowed to grow 6 plants in their own home. So you could theoretically have a co-op of 3 people, have 18 plants. Denver's limited that to 12. That will probably be challenged in the courts, but that's something they've done to limit number of plants in homes, because I'm sure some of you in this room have seen it. If there's a grow in the home, there can be major impacts to the home, structurally, foundations, etc. Definitely an issue, and it's not always disclosed. In many cases, is not. Community impacts and zoning limitations are kind of go hand in hand. I think what we've seen is that the supply is not meeting the demand right now. There's a number of retail stores currently in Denver that simply just don't have the supply to meet the demand. And the reality is there needs to be more production, but industrial space where you can actually establish a grower manufacturing facility is very limited. So either other communities will allow it, ones close to Denver, to provide the product, or you might potentially see some rezonings of land, which obviously are going to be extremely contentious because it brings that industrial growing areas closer to single-family communities, and you want to manage that balance between the industry and maintaining those communities. With that, I'll turn it over to Scott.
So he's a wealth of information, isn't he? Great job, Peter.
Thank you, guys. This topic is full of levity. No pun intended. It is, it's funny, in the last couple of years as this topic has emerged, it was something that had any time it was brought up, there were snickers, all around it, and now it's become, a reality of our lives here in Colorado, whether it's dealing with real estate issues, whether it's discussing the topic with kids, with our own children, whatever that is, it's become a reality for all of us. And so my section here is really kind of meant to address stuff that's going to be applicable to, I think, you guys in your day-to-day practice. The single most important point for property owners, for your clients, is that marijuana is still illegal. It's legal here in the state of Colorado. It's a constitutional right, but when it comes to conflicts between federal drug law and state drug law, federal law wins. And so as Peter alluded to, what we have now at the federal level is not, there's been no change in the legality of it. There's been nothing's changed constitutionally at the federal level. Nothing's been changed with the legislature. It's really just a federal position that the United States Attorney General has said that we are not going to enforce marijuana drug laws that are enacted at the state level. That could change with the change of an administration, with the change of an Attorney General, with a change in the wind, really, if they so decided. So all of that as a backdrop for context is important to understand, because there's a lot of property transactions being completed now in reliance on income from marijuana growth, sales, and people are making decisions based on that. And so it isn't something that necessarily can stay around forever. Politically, it's a hot button issue and may become more and more hot as things change at the federal level, if they change. So what does that mean to me? Well, it means that you have the right and the obligation to control what activities take place on your property, both as a property owner. If you're a tenant with a property right to a property, it's your obligation and it's your right to control those things. So there's a lot of questions that we get on the hotline related to, particularly from property managers, saying, "Hey, what can I do about this?" And it's your right to control that if you care to control it, and frankly, it's your obligation if something were to happen. So, dude, why should I care? Well, you should care because most commercial and residential leases have a catch-all provision that prohibits illegal activities on the property. So marijuana is illegal under the federal law, and therefore it's illegal technically based on your lease. Most property insurance policies have exclusions for damage to property caused by illegal activities. So if you have a property and you've got a tenant in there, whether it's residential or commercial, and they have a grow facility and there's an electrical fire based on hydroponic lights and kind of a grow operation, a property insurance company could theoretically preclude coverage if there was damage done to that, because again, it's technically an illegal activity. Most of your loan and financing documents have covenants prohibiting illegal activities on the property. So, kind of the same thing applies. You're theoretically, at least, or technically, I should say, in violation of your loan covenants, because those are all read from a federal standard as opposed to a state standard. Most banks adhere to internal and or federally mandated lending criteria that prohibit lending for illegal purposes. Same thing applies, to the former. And then, most owners associations, HOAs, have covenants and restrictions that prohibit illegal activities as well. So while it is technically legal and a constitutional right within the state, if you're a property owner, property manager, or even a tenant, you could be in violation of your loan documents, your insurance policy, your lease document, and your HOAs. So leasing considerations, and my eyes aren't good enough to read my own print up there, so I'll cheat down here. So you have the right to specifically prohibit or specifically allow marijuana use, sale, and growth on your property. Again, this is all subject to the last slide, which talks about there are probably external documents that you're a party to that might well prohibit that as being illegal, but from a leasing standpoint, you can specifically prohibit it and you could specifically allow it. So if you want to specifically prohibit it on your property, you should feel comfortable to stand strong. Marijuana users, sellers, growers are not a protected class. You can't discriminate against them just yet. And you're free to say no and to include such prohibitions in your lease document. There's an interesting, just a couple of weeks ago, the Colorado Supreme Court just heard a case related to employment law, and we have not really had any direction from the courts with respect to how to interpret, our state constitution when it comes to this issue. But just the end of September, there's a case called Coates versus Dish Network, and it's a paraplegic or quadriplegic gentleman that was using medical marijuana in 2010, pursuant to state statute, legally, and he was a call center operator for Dish Network, and Dish Network terminated him. He has since sued, and so the Colorado Supreme Court just heard the case a couple weeks ago, so I think we'll get some direction with respect to employment law, but it's very likely that opinion will hold some information that might be instructive with respect to real estate law and what rights are, particularly as it relates to medical marijuana and ADA considerations and things like that. So I would imagine in the next couple of months there'll be an opinion that'll potentially give us at least a little bit of direction on the issue. So if you want to specifically allow marijuana on a property, you need to be very clear. And the most important thing you can do is to have a clause in there that allows for a very flexible termination right in the event of a change in the current state law or the federal position on marijuana. As we know, in the past, drug laws have allowed for seizure of property in the event that there is drug activities taking place on the property. The same thing could reapply. Those laws are already on the books. So if there was a change in the federal position, as property owners, as property managers, for your client's information, they need to have a clause in there that allows them to terminate a lease in the event that there is any change whatsoever, either at the state level or the federal level. And so, and throughout the lease document, you've got to consider the implications on property insurance, on existing mortgages or financing agreements, on new loans or the ability to refinance. I think we've seen a lot in the commercial realm of situations in the last couple of years where owners have put grow facilities or distribution or sales facilities in commercial properties, and they've gone to turn around and refinance that property now because they've got good income on it, but banks say, no chance. We can't refinance you because of the use. You got to be cognizant of municipal zoning and deed restrictions that may be imposed on the property. Rent expense and collection. You need to address in the lease how the rent's going to be paid. I think Peter alluded to the fact that there's not really a banking industry that is capable of supporting this at this point. So most, when I represent marijuana clients in my law practice, frankly I get paid with money orders. I don't get checks. They send me money orders as payments because they don't have an ability to cut checks. And then you've got to consider the future marketability of the property if you're going down the road with that use. So if you're representing a marijuana buyer as an agent, consideration...
Buying real estate.
Yeah, not buying dime bags. They were dime bags when I was kids. I guess they're eighths now, so... I don't know too much about that. So if you're representing a client that's looking to buy either an existing marijuana facility or to buy a property that they're going to use for marijuana type uses, you got to think about financing. As agents, none of us like to waste our time with clients, of course, but are they financeable? It's not just a matter of going out to a mortgage company and getting a pre-qualification letter so you feel comfortable spending your time running around with them. Because that's not probably where the money's coming from. It's very unlikely that it's going to come from a traditional source. It's probably going to come, if it's not cash that's kind of private money, it'll come from a hard money lender, a secondary market. And so you need to make sure that the buyers are qualified to get financing. If your buyer is looking to grow or distribute, sell marijuana, then as an agent, you've still got to be responsible for making sure that that the property that they've identified that they want to purchase is that use is within the municipal zoning regulations, and consider proximity to schools and everything else that might restrict their ability to do the business that they want to do. Property insurance, obtaining it for that use can be difficult, so you want to keep that in mind. For your clients, if there is a change in the federal position on this, are they buying a property that they can repurpose? In other words, if they're buying it for just that use, and if something were to change, then they might have this worthless building, in the middle of Commerce City that doesn't have much utility beyond marijuana. And then consider any unique power, utility, or security concerns with respect to the property. Grow facilities. They take an inordinate amount of power. I've seen facilities that, 40,000 square foot facilities stacked double high, and they've got backup generators and everything else to handle the power needs. The air circulation, the HVAC units are very, very intensive. So those are things you have to be thinking about as you represent a buyer of a property for marijuana. So if you're listing a property that is a marijuana facility, some things to consider: showing restrictions. There's probably going to be areas of the home or the business that a potential buyer can't access, so it makes it a little bit more difficult to show. Source of funds. Once again, if you're going down the road with a buyer, you're going under contract with a buyer, you really want to make sure that they're financeable. If you're selling with a lease income in place, in other words, you're selling an investment property that has a marijuana grower or sales facility involved, is that tenant going to be considered creditworthy if the buyer if your buyer is looking to get financing, or if the seller is looking to sell it to somebody that's going to be basing it on income from a lease in place. And and then homes. Is the new home a former grow operation, or did it have an extensive grow operation? You got to be looking at, again, have there been property insurance claims that might preclude the new buyer's ability to obtain insurance? Did they hamstring together electrical wiring and water for hydroponic grow facilities? Could it be considered a stigmatized property? Those are things you need to be thinking about as you go and market a property for sale. So big question here with both marketing and the material adverse condition discussion. Is it a material adverse condition if you're selling a home that was a grow facility? I guess it depends on the circumstances. Again, it gets back to, was the wiring done to code? Was it permitted? Was the plumbing done to code? Was it permitted? Is there potential for mold? Again, lots of water used in these indoor grow operations. There's I think a greater risk of mold in a humid grow environment. Is it stigmatized? Is it a well-known grow facility or dispensary? The new buyer is going to have people showing up at their door looking to buy marijuana after the fact. I think if that were the case, and there may be some buyers that are pretty frustrated that wasn't disclosed to them ahead of time. And as always, as realtors, we're going to err on the side of disclosure. It just makes sense. I think, candidly, anymore, the topic is people are becoming more and more comfortable with it, and certainly it's not like meth where there's airborne contaminants and other threats or hazards. So it probably makes sense if you're selling a home or a commercial building that had a relatively extensive grow operation inside to go ahead and just disclose that for the sake of everybody's comfort. And then on a marketing side, as agents, you got to be careful. If you're selling a building, is it appropriate? I see a lot of commercial, brochures, commercial marketing, and it'll say, "Oh, perfect grow facility." And I mean, this is in the event that these facilities even hit the market, because frankly, almost anymore rarely they do. If something is zoned for a grow operation, it's snapped up very, very quickly. But I do still see, people marketing things as being perfect for grow, perfect for dispensary. If you're going to be marketing that way, you need to make sure that that's the case, because, and that means getting into the weeds a little bit in terms of what a buyer is going to be able to. I just made a pun, excuse me. I literally didn't mean to do that, but it's amazing.
But you'll use it in your next presentation.
There you go. So anyhow, consider zoning and any municipal requirements. And that's the end of my presentation piece.
Great. Again, let's give Scott a big hand. So we've only got 2 mics, guys. What I'm going to let you guys do is use this one. And we're going to open up for questions now. So if you guys want to raise your hands, I'll come around with the mic and ask the questions. Let me start with the first one, Scott. One of the things that you had mentioned was that if there's a change in the federal position, what this could do to the industry. So again, we all know how many years and what it took to get it legal in Colorado, and he made it clear to you that it's still illegal from a federal standpoint. Marijuana is still illegal, and it's just the federal position that it's taken right now that's allowing this industry to take place in Colorado, which is turning into hundreds of millions of dollars, right, all over the state. Tell us what happens if there's a change in the federal position, i.e., we just had a change in the Attorney General, right? Although he's probably getting some orders from upstairs. But we have an election coming up next year. And so there's a possibility that the federal government could change its position on this issue as soon as 2016, 2017. Why don't you speak to that?
Well, I think that'll ultimately be more of a political question than anything, just because a new administration is going to be cognizant of the successes and or failures that have occurred in the states that have legalized medical marijuana, or the smaller handful of states that have or will have legalized recreational marijuana. The real impact could be pretty dramatic, I suppose, if they were to decide that they were going to just revert to the former position, which was we as a federal government have a right to come in and shut you down and theoretically to seize property. I think you'd see particularly the industrial real estate market would get into some pretty quick turmoil potentially, because there is so much of it going on, particularly in the counties where it's been accepted, that it would have, I think, potentially a pretty negative impact on the industrial real estate market. Retail, probably not so much. There's a lot of dispensaries in Denver. and some of the other counties, but those are generally smaller spaces. Again, I think the difference you see in the grow facilities is they're massive, and you can drive north on Brighton and go east or west in any direction, and you don't even know you're driving by them, but they know you're there because there's cameras everywhere, quite literally. And if a lot of that space were to come back on the market, then there would be an impact potentially for an oversupply of industrial real estate.
Who else has a question?
So I'm sure we've all showed plenty of properties, REOs and whatnot, that have clearly been grow operations at some point. I'm just curious, what's the bank's responsibility for cleaning those up, if anything, knowing that there was an operation in there?
Well, I mean, banks that's part of the marketability issue for banks dealing with REOs. I mean, most banks will say, it's as is. We're not doing anything with it. I mean, frankly, from a cleanup standpoint, I'm not sure how extensive, unless somebody was really growing outside of their legal rights within the property. I mean, again, they're contained in most cases to 6 or 7 plants in a home in a residential use, and so I don't know that the cleanup piece is necessarily extensive, but the banks don't have an obligation to do really anything. I mean, it's much like anything else with an REO. They're going to wipe their hands of it and say, get rid of it, and if that means reducing the purchase price to find the right market for that property, then ultimately that's what they'll do.
Other questions?
Marjorie Genova, Grand Junction. My question is, just as a normal residential realtor that sells property, residential property, so you're in a house, it's your listing maybe or maybe not, you're just showing, you're out on the patio in the backyard, it's the perfect house for your buyer, and you can smell marijuana from the neighbor. Does that listing or the seller have any rights? I mean, everybody owns their house. We're not talking investment property or growing or I don't know what they're doing inside, but outside they are smoking pot in the backyard, and you can smell it up and down the backyard neighborhoods. And the seller is like, some of the buyers definitely are saying, forget it, I'm not buying this house because I don't ever want to have to deal with that neighbor, and I don't want to smell pot in my backyard when I buy the house. What rights does the seller have?
Yeah, I mean, unfortunately, I wish I had better news for you, but very few. It depends if they're smoking marijuana and it's within their backyard, probably very little rights that they have to really stop it. Now, if it's a marijuana grow and it's outside in their backyard and you're smelling it from that, and it's an open grow, what we've seen is that these local municipalities haven't allowed open grows. But in terms of someone smoking on their front porch, their backyard, there is very little you can do. I've seen city councils debate this issue over and over and over again, and they really feel as though there's a lot of gray area with the constitutional right. It is your constitutional right to smoke on your property, albeit it can affect someone. You can probably sit there and complain and call the authorities, but even authorities have sat there and made it clear that it's a very low priority for them. Yeah, I would say you can. I've read a lot on this. I think attorneys on both sides, one would say, it's someone's constitutional right to smoke on their property. Is a backyard considered their property? I've seen others that said covenants allow you to waive your constitutional rights as long as 2/3 of the HOA agrees to it.
Yeah, if they're adhering to the bylaws for the implementation of the covenants, then, or if a developer is developing new covenants and they want to put that in there, then certainly, I mean, one of my slides was, if you want to specifically exclude it, then you have a right to do that. And so if a homeowner association as a group decide they want to do that, then they could say, we don't want to do it outside.
That'd be hard to change existing covenants to have that, but new covenants.
Sure. Sure, and you could change them pursuant to the bylaws. I mean, if you wanted to go back and change them for existing, but you need to have whatever buy-in from the percentage of ownership is required to change, any covenant.
My question, you may have answered it, was about if you didn't want to grow it inside, are they allowed to grow it outside in their garden, 6 plants? No.
No.
That open grow, that covers that.
Yeah, you can't grow anything outside. It's all indoors.
Are you saying in general, or are you saying in specific targeted lease homeowner properties?
For growing, you're asking?
Yeah, like if a guy has a 5-acre rental and he says, yeah, let him grow, you're saying it's illegal to do that?
Yes.
Okay.
Yeah, there's no counties. Nobody allows for outdoor grow whatsoever. That's a legal. I mean, that's a statutory or issue. You can't give a property owner or a tenant more rights than the law gives them.
So I know with methamphetamine, you know, there is a specific mitigation process that removes the required to disclose. If you have some sort of a grow in a house and a buyer wants that mitigated, is there a standard for doing so, or that would remove the required then to disclose further? Or is there anything that is suggested to clean up a grow facility of any sorts?
Yeah, I mean, not that I'm aware of. I know, you know, for instance, meth facilities will have, you know, there are people that are licensed to remediate, you know, methamphetamine labs. But in terms of marijuana, you know, I think it's really it's more of a sensory thing. In other words, you know, it may be the same as your buyer is requesting that, you know, pet odors or that kind of thing is remediated prior to closing. I mean, it's an inspection objection that any buyer is perfectly entitled to make. But I don't. Only from a marketability standpoint would there be an obligation on the seller to remediate that.
Who else has a question on this side?
I have a two-part question, both of them related to, John Gallimato, Durango, Colorado. Two-part question, both of them related to the funds that are brought into it. With the rental income, I deal with a lot of folks that are out-of-state investors buying property here. If they're taking those dollars in through cash or money orders, whatever they're getting paid for, putting that into their account that is now out-of-state or really any rental income that's derived from the sale, does that not fall under the same guidelines as any income derived from marijuana sales that can be restricted? And since they're out of state, are they at more liability for that? So that's the first part of it. And then the second part is I do a lot of work for school districts in our part of the state, and looking at facilities, looking at future improvements, knowing that everything under Amendment 64 is kind of a waste because you can't bond against illegal dollars, so any of those monies that exist will never go to schools as it stands right now. But if you have local dollars that are driven to the local coffers, even from the state to state general funds, is there the potential of us trying to go after bond dollars and them saying, well, X% of your income is derived from those dollars, and so, I mean, could that jeopardize Colorado as a whole for those federal programs, federal dollars?
Yeah, Peter's well-versed in probably the second answer. The first question, I'm sorry, I misunderstood, or maybe I misunderstood a little bit. Are you talking about in terms of withholding at closing for an... On
rental income specifically. So if I'm an out-of-state investor or even an in-state investor, and I have rental income coming in, and I've got rental income coming in, how is that any different than any other income driven from the sales? And again, if I'm an out-of-state owner and I'm taking those dollars that I'm getting in cash from those locations and putting into my accounts, what's the difference for those people? You know, because I mean, I'm looking at it in a couple of years, thinking that there probably will be a change, and how is that going to impact those people?
Yeah, I don't. The difference is that the income you're taking in from a tenant as an investor is derived through the lease document. I mean, that's the genesis of that income, is by giving a property right to somebody. The income that's being taken in from from a dispensary or a grow facility is being derived from the sale of marijuana.
So local contract law or state contract law supersedes federal law?
No, but if you're an out-of-state property owner, you're taking income in for a property relationship, not for a marijuana relationship. The use in the facility may be marijuana, but the income is coming from a lease document. That's the genesis of it.
So in that situation, state contract law for the lease will supersede the federal part of it?
Well,
Well, because if I knowingly lease to somebody that has a meth operation, do I have no liability in that? What's the difference?
no. Okay, so yes, I guess I see. That makes your question a little bit more clear. No, you're acting under state law, and as a property owner, if you're knowingly leasing to somebody that is performing, meth or an illegal activity on the property, which I guess as I discussed, this is part of it's a business decision. I mean, there's a lot of downside from if you're a commercial investor or if you're a residential owner and you're leasing to somebody where eyes wide open, they're either growing or selling or using marijuana on the property. All of the other things that I discussed earlier are at risk. Your loan covenants, your insurance, underwriting. So you're making a business decision. The reality of it is those tenants generally pay more, particularly on the commercial side. They'll pay a disproportionate amount per square foot. But so I wouldn't necessarily. It's an interesting question you ask, actually, because to ask whether at a state level the contract law supersedes federal law, I don't think that's the case. But again, this is something that from a property rights standpoint, the federal position has said we're going to look the other direction. And so a lot of commercial owners, they could probably double or triple their income stream, but just for either moral or other principled reasons decide they're not going to lease to those uses, period. Then there are a lot of people that are driven by the income stream, but it's a business risk technically if something were to change and enforcement were to change. So I hope that answers your question, and I'll let Peter take on your second one real quickly.
I'm glad he took that one. In terms of the dollars for schools, the way it worked was the first $40 million of excise tax on the wholesale retail marijuana would go to capital school construction. $40 million was a pie-in-the-sky number, be completely honest with you. And it also was a loophole in Amendment 64 that allowed current medical marijuana facilities that produced and growed a one-time tax-free transfer to retail facilities. So what you've seen in order to supply the new retail industry is all those medical grows have done their one-time retail transfer. So the state's lost out on a pretty significant amount of money, probably $3 or $4 million in the first 4 years, and they'll bring in a little over $1 million. Jeremy Meyer with the Denver Post wrote a good article on it. So it's things like that prevent the state from getting the dollars that they probably should have, and they weren't going to get the dollars to those levels to begin with. To really kind of get at your question, it's difficult to sit there and make the argument to a local jurisdiction that you love a piece of those funds, because at the end of the day, they're not sitting there and getting enough revenue to really outspend their expenditures to the point where they're able to really give away those funds. The issue, and I think it always and will continue to be, is are the revenues that we're bringing in with this industry exceeding the expenditures, and by how much, enough to look at other potential sources to give those funds. At this point in time, revenues are not really greater than expenditures, which are used to pay for the unintended consequences. So I think that's a difficult argument for you to make. Sounds like you need a lobbyist. I'll give you my card.
And I'm glad you answered that question.
Linda Romer Todd from Grand Junction. If you're dealing with a lot of property management, you see a lot more turnover of the issues. And my concerns are, as a realtor or a property manager, how far do our liabilities extend and our obligations to our landlords in not allowing the grows to happen, because they do whether you want to or know or not, and then to the future tenants when we have cleanups. And I will use an example that it's far more common than normal, is you rent to somebody in a townhouse unit in a fourplex, and they dig up the backyard, and you have 6 to 12 inches of dirt in the upstairs bedroom where they're watering, and then they've cut a hole in the ceiling so that they can vent it. And it just goes on, and then in the middle of the living room, you've got water coming down, and your water bills go up $50 a month or more. So that's what makes you go back and check the facility. But we're putting our owners in jeopardy because of their insurance, because of their loans, and the conditions of the property. But also, the second part is, what's our obligations after we try to go in and clean that up or do clean it up to the future tenants?
Well, I think it's a disclosure issue to future tenants. As I said, it's probably, it doesn't hurt to disclose, I don't think. I mean, what the example you gave is, I think, an extreme version of what's going on. I mean, and if somebody's punching holes in the ceiling, or they're doing significant damage to the property, then that'd be covered under the same things that, any other damage to the property would be covered under. And the liability for the tenant in those cases would be the same as it would be, for anything else that they were doing that would cause that extent of damage to the property. Again, disclosure is, well, I think it's probably more important in a for sale case, from the standpoint of, if somebody was wiring a property or modifying the plumbing to service a hydroponic thing, or putting in really intensive lights that drew a lot of power, that kind of thing. I think it's probably wise to disclose to either a buyer or a tenant that this has been done. But in terms of your own liability, I don't. You've got an obligation as an agent of your client to enforce the terms of the lease. And so, to the extent that you become aware of activities that are in violation of your lease document, I think you've got an obligation to enforce those, whatever they may be.
All right, we've got time for one more question. Again, keep in mind we've got another hour that we're going to be here and answering question.
Diane Haynes, Montrose. And my question is on an owner carry property on a piece of land. It's a large piece of property, and say they were growing well out of the range of growing marijuana, and they were arrested. Would that come back on the property owner that is leasing the property, owner carrying the property? And could that property be seized? And another thing, would it come back onto the realtor in any way, the buyer or the seller's agent?
The most important question was the last one.
Yeah.
Well, not unless you had an active property management responsibility for the property. I don't think you'd have any liability. No, so you sold a property that was being grown on extensively, or you represented a buyer that bought a property?
I represented
the seller. Yeah, I mean, yeah. Well, so the seizure laws could come into effect at any time. I mean, if the federal government decides that they're going to change that, I don't foresee any scenario by which the federal government's going to say, you're done, and then the next day we get 10,000 DEA agents dropped on the state that start seizing properties. I think you'd see a phase in of the change in federal position. So I think it'd be over the course of 6 months or 12 months or something. There would be lots of notice to property owners to say, listen, if you've got uses on your property that are in violation of federal drug law, you better clean them up and get them out. And by such and such date, we're going to start, enforcing our rights potentially with respect to seizure. So I don't think there's any necessarily immediate risk of that. I don't think that's the way that it would be implemented, frankly. Yeah.
All right, great. Again, you can see this is an evolving topic, and it's so new that until we get some case law and some people challenging things and the court establishing what the parameters are, a lot of us are in the dark. So even us advising you guys on certain things, it's hard because there's not enough established law on it. So I could see that we'll be addressing this topic probably for years to come as we have these things. With that, thank you guys very much for being here. I'd like to thank these guys for being here. And we'll break for about 10 minutes, and then we'll come back with the legal panel with the Q&A session.